we certainly don't advise from Sakeliga's side that you try and restructure your business and start doing business on these political terms as if they're not going to change, because that's a losing game plan. So that brings us to the option that we think has the greatest potential.
Well, good afternoon, ladies and gentlemen. It's great to have you joining us this afternoon for our webinar, PPRA, BEE and FFC certificates. What now? This has become an incredibly pressing issue for the property sector, and we are going to talk about that today. I hope you can all hear us well. There are a lot of people joining. We've had a substantial surge of interest for this webinar. There's a huge amount of focus going on regulatory issues in the sector right now, particularly around BEE, and we're going to get into that today. Let me say at the outset that we are going to be taking questions. The way that we're going to take questions is that there is a Q&A bar in your webinar platform there, and you can go and type your question there. And we are going to treat all questions anonymously. So whether you put your name on the question or not, we're just going to read out the question as an anonymous question. So please, as we go through the webinar, if a question pops into your head, you're very welcome to put it down there. And we will try and leave as much space as possible later on in the webinar for fielding some of the most pertinent questions that that we get. As we look ahead to the next half an hour or so of us getting into this issue, we're going to just look at what this means for your business. We're also going to give you some context on what we call Wave 3 BEE, which has now arrived very urgently in the property sector. We're going to give you some context on that. We're going to talk about who is affected now. And that, of course, matters for the expansion of the definition of property practitioners. We're going to look at what Sakeliga is doing and what that means for your options. And then, of course, how you can support us in our efforts to resist what we believe is a very, very harmful wave of BEE. And we must stress at the outset, Sakeliga regards the goal of a thriving black business community as a laudable and important goal. And we think that BEE is an inappropriate means to that end. We think that BEE does more harm than good. It harms economic growth, and it is seeking right now through the regulatory processes of the PPRA to bring substantial harm to the property sector and beyond. Sakeliga is a business organization. We've been around since 2011, and we are an independent non-profit company. We're a public benefit organization working for a thriving economy, and we do this through comprehensive public interest litigation, as well as developing alternatives to failing state governance structures. And it's really the litigation dimension of what we do that we're going to be that's relevant for today. We focus our efforts on key threats to the South African economy that arise through attacks, policy attacks on trade and property rights, through state failures and policy errors in key infrastructure like energy, and so on, and then, of course, safety and security. Without safety and security, without a safe and secure operating environment, with sound shared infrastructure, and with freedom to own property and to trade, we don't have a thriving business environment in South Africa. That is our mission, that is our goal. And BEE, we see, is one of the key threats to a thriving business community in South Africa. Why do we do this? We do this for a secure and prosperous future in the place we love, for our children, for our grandchildren. We love this place, and we want to see a thriving economy with thriving businesses from all communities. And so that brings us to why we are sitting here today. We see a considerable threat in the property sector. I'm going to bring in my fellow panelists here. Let me introduce you to Piet Roux, Sakeliga's CEO, and Tian Alberts, legal officer at Sakeliga, constituting a significant portion of the Sakeliga internal legal team. We have external attorneys as well, and we'll be talking a bit about our thoughts on litigation around this particular issue. But Piet, before we get too far ahead of ourselves here, I want our audience to understand that what they're facing from a BEE regulatory perspective in their sector is not unique. It may be one of the most advanced and pressing threats we are seeing in the country right now, but this is a threat really that is coming for several sectors. Perhaps quickly you can contextualize where this threat is coming from. We call it Wave 3 BEE. That means there must have been a Wave 1 and a Wave 2. Perhaps just give that broader context of how we got to where we are today.
Russell, that's an important question because we have to stop what's happening in the property practitioners regulatory authority now because it's very harmful. But it's not isolated there, and it's happening across the economy. And so when we'll get into the conversation later about what can be done, what I'm going to say now is why it needs to be stopped. So there are 3 waves to BEE, and the first one started in the 90s. And the 90s was a mixed, some great things happened and some problematic things happened. In the 90s, one of the great things that happened was that the regulations that stifled intercommunity and across racial lines business, that stifled that kind of business, were lifted. It was like lifting sanctions on yourself, self-imposed sanctions. And you have this amazing freeing up of doing business. And in unprecedented terms, you could do business with anybody in the country and nobody would question the race or restrict you based on the race of your business partners or your clients or your suppliers and so on. So that's an amazing thing that happened in the 90s. But at the same time, something else started happening. And the term BEE, Black Economic Empowerment, was coined. And it was coined in the run-up to the 94 election in ANC policy documents. At the time, incidentally, Mr. Cyril Ramaphosa was Secretary General of the ANC then. And in these documents that they developed, they coined the term Black Economic Empowerment. And what form did it take then? It wasn't enacted. It wasn't a statute, a law, or legislation. What it was a policy position. And that policy position translated into soft pressure, soft political pressure, sometimes hard pressure. And so the 90s is this two-stream thing where 2 things happened. One was you have a freeing up of the economy. You can do business to generate value regardless of race. But you also have enormous wealth being generated on political terms. You can say generated or destroyed or reallocated. But you have political pressure getting companies to do lots of so-called BEE deals. There was lots of criticism at the time because it was evident some people were getting really rich in this era at the cost of, everybody else that wealth was transferred from. And also it happened at a time of amazing goodwill in the country. Everybody wanted in this new strictly unrestricted business environment, do business across racial lines. And so, unfortunately, something else took hold in the 90s, which was this political pressure.
And so the 90s, that phase 1, wave 1 of BEE represents a complex period of freeing up of racial restrictions and almost simultaneously the slow establishment of new racialization of the economy. That brings us through the 1990s to the BEE Commission of the early 2000s. And essentially what's going on there is certain people feel that there is, despite 300 billion rands worth of deals in today's money happening before the end of the 1990s on the JSE alone, anyway, people feel that this is not going far enough. And the BEE Commission comes in and essentially moves us into a statutory phase of BEE or wave of BEE. Perhaps you can just elaborate on what wave 2 looks like.
Yeah, so wave 2 then starts in the early 2000s on the back of these recommendations by the Black Economic Empowerment Commission. It was an entity chaired by then not yet President Cyril Ramaphosa, but he chairs this, makes recommendations. And in 2003, President Thabo Mbeki announces in his State of the Nation address that, these recommendations say that BEE should now be there should be an act. It should become a part of the legal framework and compulsory. And so he announces that there's now going to be a BEE Act. At the same time, the Procurement Act from government's Preferential Procurement Framework Act comes into play. And then we have 15 years, roughly from early 2000s to 2018. That's wave 2. What we have there is if you want to do business with the state, you have to do some element of BEE, and you're going to be penalized if you don't. You're going to lose 10%, 20% of your points. But it's only if you do business with the state. So it's a vertical restriction on doing business. There is a chain reaction through the economy because through the supply chain requirements and if your suppliers, you're also going to be scored based on who you deal with as a company dealing with the state. So there's a limited chain reaction. It's harmful, but it's limited because if you can escape during the second wave of BE, if you can escape doing business with the state, you're still free to do business on your own terms.
Yeah.
You can do business with anybody in the country, and you're not going to be required. There are some exceptions, maybe in mining, in fisheries, and so on.
Yeah.
But that's where there are arguably limited state resources and state intervention. But in general, it's still free business environment unless you do business with the state. That's wave 2. But Russell, that starts changing, and to our audience, that starts changing by 2018. Is really the turning point, and we see under Minister Ibrahim Patel, then Minister of Trade and Industry, a new act coming into play, some changes to the Competition Act. And for the first time, we're now seeing not restrictions just on doing business with the state, but doing any business at all. So the Competition Act changes, and it says if you want to do a merger and acquisition, one company wants to buy another company, no state involvement. We're now going to measure that transaction for its BEE score.
And essentially impose BEE requirements on the transaction.
Yeah, if you want to do a transaction, we're going to impose BEE on you. Now, it wasn't always successfully done, but it starts happening in 2018. The act changes, and you see BEE spreading out, infecting other acts. So where it was only the BEE Act and the Preferential Procurement Act of the early 2000s, now you see words like Black Economic Empowerment and BEE seeded directly into other acts, like the Competition Act and, important for this conversation, the Property Practitioners Act, of a little bit later, but only came into effect last year. I'll get my dates now wrong, but point is the Property Practitioners Act is another example of this. So third wave BEE is where we move, we flip this thing on its side, and government starts saying, if you want to do business at all, you're now going to have to apply our political preferences to your business transactions. And if you don't, you're either going to be penalized or prohibited from doing any business at all. And the modus operandi is to not only start requiring BEE, but also to redefine industries and make the scope, the reach of government stronger. And it's especially relevant to our audience today because before the Property Practitioners Act, only estate agents really were affected by the Estate Agencies Affairs Act. But now we see an example of the redefinition of an industry. We see a new term, property practitioners, and not only estate agents, but now property developers, attorney, people who do bond and mortgage origination. 12 new categories. We'll get into these 12 categories now all become property practitioners. So you have this great expansion of the reach of the regulator, and then with that, the requirement to do BE. And that's wave 3. That's where we are now. And that's the wave that we have to stop because we're in the early days of it. And if we let it take hold, it'll be 10 times the damage of wave 2.
And it's coming first and foremost for sectors that are subject to licensing, where the state can withhold something from you and therefore render your operations as a business unlawful without said certificate or license or so on. That's where they are coming for. And so step 1 of that is to expand the scope of licensing, of required licenses, and we've seen that in the expansion of the definition of a property practitioner and who needs an FFC certificate and so on. And of course, and then step 2 would be to then attach various things to those licenses. And I do want to stress that BEE is a significant component of this now, but really it's actually a subset of broader socialistic government policy. If you can expand licensing way beyond the scope of what it rationally applies to, and then you can start to attach all sorts of preconditions and conditions for operating that really could go in all sorts of directions that are tremendously harmful and arbitrary. And so something we have to absolutely squash. And so in opposing the BEE portion of this threat, it actually has more implications, not just across different sectors who are affected similarly by this, but to things other than BEE that might be wrongfully attached to licensing. So this is an incredibly important issue that we are discussing. Piet,
Russell, let me get into because we said we said we'll tell you who's affected, and now in the media and a lot of estate agents would be in this call today with us, and you know that it affects you, and in the public's mind it mostly affects you. But let me read to you the 12 categories of because of this redefinition of expansion. So 12 categories of who's affected under who's counted as a property practitioner: estate agents, auctioneers, bond and bridging finance originators, homeowners associations who perform property practitioner activities, managing agents, property facilitators and intermediaries. So if you're a management agent, if you're going to fall under this, business brokers, including sales of franchises and business undertakings, developers who perform property practitioner activities, including project managers, development managers, investment sales agents, timeshare and fractional ownership practitioners, property advertising platforms. These online platforms are all property practitioners. Property practitioners who specialize in collecting and distributing trust monies, and even attorney employees. So we have 12 categories. And what happened in the early days, like a year or two ago, only estate agents were mostly affected because the Property Practitioners Regulatory Authority hadn't built the systems yet to rope in all these categories. But we're now at that stage where everybody's being roped in. So let me just expand there.
Tian, I'm going to bring you in here. Can you just give our audience today, many of them will be aware of what they're facing, but perhaps we need to just give a succinct kind of summary of the threat. What is currently the pressing threat that is coming forth from the PPRA? What is the threat in the property practitioner sector around BEE and their ability, people's ability to operate lawfully?
Yes, Russell. So in 2022, the Property Practitioners Act was promulgated. And so there was this new focus on transformation, and specifically Section 50AX of the Act. So you just referred to BEE creeping into other acts, Piet. And this is an act where the foothold for BEE was sought to be placed under the FFC requirement. So we knew since 2022 this is going to be a problem, and this is coming. But we always wondered how the PPRA was going to implement this. And the idea was, or the worst case scenario back then was that the PPRA would just require a valid BEE certificate. So if you have a certificate that was issued by a valid BEE agency, you are clear.
And for total clarity, that valid certificate can say non-compliant.
Correct,
Or, or not zero BEE.
Correct.
Points or whatever.
The Act, as it stood and it still stands, does not compel BEE compliance. We still take issue with it. Tian will get into it, but yeah, for total clarity, the Act does not say you have to participate in BEE.
Correct. Yes. So and the FFCs were issued in 2022, valid for 3 years. That period is coming to an end, where practitioners need to reapply for an FFC. So now, just 8 months before practitioners would need a new FFC, the PPRA comes forward.
This is only estate agents now, because some practitioners need FFCs right now.
Yes.
But the estate agents 3 years ago got theirs, and
Yes.
most of them are still
Yes.
in place.
So looking forward into the next few months, practitioners now need to look at reapplying estate agents for this FFC. And the PPRA suddenly comes forward with this notion in a webinar that you need to actually have a compliant BEE certificate. And they make the argument that, well, it's contrary to the purposes of the Act to interpret valid as not being compliant. So they raise this argument. And the problem is that practitioners have been informed otherwise in the past by the PPRA. there was this notion that this is for information gathering purposes, and we only need a valid BEE certificate.
Okay, so just again, for total clarity, there's now becoming a distinction here that the PPRA is bringing in, that it's to say on your BEE certificate non-compliant or non-participating or whatever it might be. They're now saying no, that's no longer a valid certificate. A valid certificate means you are doing BEE. You have level 8, 40 points or whatever the minimum threshold is. They're now bringing in an actual explicit requirement to be participating in BEE.
Correct, yes. So they apply a very creative interpretation of the Act, and through that they seek to impose an additional requirement, which is not in the Act. So if you look at the Act, there's no requirement for a compliant BEE certificate. And also what is interesting is the PPRA used the Property Practitioners Code, the BEE code, as a basis for this, but there's no mention in the Act itself of this code.
Okay.
So with a lot of maneuvering, they try to insert this requirement into the Act. And it's also interesting, just to get back to earlier points, if you look at the conventional requirements for a Fidelity Fund certificate, I mean, this is all about certifying that someone is capable and trustworthy in terms of handling trust money. BEE has no connection to that.
Not only is BEE completely unrelated to that, but also many of the areas that they are trying to apply FFC certification to don't sit with trust monies. I mean, that would at least be conceivable to me that many of them would never sit with trust money. So this is just overreach of licensing.
Exactly. Russell, so maybe this is an appropriate time so Tian's identified we take issue in the Act with the requirement to have a BE certificate. So we take issue with the interpretation that you need to have a valid, that you need to have a compliance certificate. We say that is regulatory overreach and outside the Act. Can be attacked, and we'll get into that, but we're attacking that. We're also saying that the requirement to have a BE certificate at all should not be in the Act. And to properly solve this whole thing, we actually need to challenge that as well. So this is part of the challenge that we're building. And then thirdly, we're saying that the redefinition of what a property practitioner is to include people who don't need an FFC but require from them to have a Fidelity Fund certificate, like a property developer who doesn't handle trust money and others. We're saying this is an extension of legislation beyond what the rational purpose is and beyond what the constitutional constrictions are. So that's the thing that Sakeliga is currently taking issue with, and that we feel must be challenged to solve this. We'll get into what your options are now because they're limited, but really to solve this, we need to attack that. Tian, have I summed that up correctly?
Yes, Piet, I think that is an accurate summary of what we intend to do in litigation.
And we've written to the PPRA on this,
Yes.
and they haven't been forthcoming in either. We've told them stop doing this. They haven't accepted our demands, or they've ceded to our demands, accepted our demands, and they also remain silent. So we're preparing papers right now.
Yes, and others have also written to them, and they don't seem to have any answer to this criticism that you can't interpret the Act in this way.
Okay, just a practical question for either of you. Have we seen yet practical instances where people are in fact being denied their FFC licenses? Are there now recorded instances of that happening because of a lack of BEE certification?
Yes, indeed, Russell. We've seen many inquiries from property practitioners indicating, actually in writing, that the PPRA isn't willing to issue an FFC because of a non-compliant BE certificate.
Okay, so we're starting to build up substantial evidence of cases where people are now effectively being excluded from the economy, excluded from participating in commerce and trade because of their race and because of their unwillingness or inability to get BEE points.
We're not saying that it's going to happen. We're saying
It
it's
is
happening. We have proof in front of us. We can't use all of that proof for confidentiality reasons.
Yeah.
We've seen several cases, and it's not happened so much to estate agents because most of the estate agents, their FFC still expires only down the line a few months from now.
Yeah.
Or
Or even into next year. Yeah.
Yeah. But if you start an estate agency right now, you're going to be denied. And if, for example, management agents have been denied and several others. So we're getting, and part of this webinar will end with that, but the more proof we get, the stronger our case is going to be.
Okay. Gentlemen, what is Sakeliga doing about it? Piet, you've alluded to some of that. Perhaps, and guys, have an open discussion. I'm not going to, just jump in as you please. You've sketched that we're drawing up papers. We're in litigation mode against this. Maybe just paint that picture in a little bit for the audience.
Tian, let me have a go and please fill in. So, what Sakeliga believes in firm litigation whenever bureaucrats move and politicians move beyond what is acceptable. And we have won several times on important cases. In the Constitutional Court, we've won 5 times, including on government procurement. We've won on property rights. So we know how to litigate.
5 out of 5 cases
5 out of 5
in the last 2 or 3 years. Yeah.
In the Concord, we've won, and we've won several in the High Court and more. So we're experienced litigants, and we think litigation is an important tool in getting people who step out of line back in line. We cannot accept a situation where politicians dictate their political preference into normal business deals. We're not implementing government political preferences. We're not going to allow that to happen. So, but we never start with litigation. We just start with correspondence and engagement.
Yeah.
We've done that now. We've reached out to the PPRA. They have not accepted. In fact, they're remaining silent. They're not forthcoming and engaging with us. They're clearly outside the scope of litigation. So we are preparing litigation. We've briefed counsel, senior and junior. They're drawing up papers, and we're building the case. Now, Tian, maybe I'm going to ask you soon just to explain to the audience what we still need to finish building that case, but we're in an advanced stage of case preparation. Let me recap what needs to be attacked. The interpretation of the PPRA on what a valid certificate means. They think it means compliant. We need to attack that. They have no right to determine what a valid certificate means. Secondly, we need to attack the requirement to have a BE certificate because it's irrelevant to being a good property practitioner.
Yeah.
And then thirdly, we need to redefine what it means to be a property practitioner, because we can't have this situation where names don't mean anything and a new term gets designed and then everybody gets clumped into that, and that means some minister can tell you what you need to do in your business.
Yeah.
So we need to get that definition of what a property practitioner is back into acceptable and constitutional terms. And we need to do all 3 of these because we're not solving the problem just by attacking a certain interpretation at the regulatory level.
Yeah.
We need to use the same opportunity to set a good foundation for a flourishing industry again.
It's no good redefining the scope of what a property practitioner is back to estate agents, let's say. If then estate agents need to be BE to operate.
Yeah.
so we have to tackle this on several fronts. Tian, do you want to add anything into that?
Yes, I think it's important for our case. We are grateful for the many people who have already come forward and provided us with evidence of what is happening. Because obviously we can't head to court on an abstract argument and make allegations against the PPRA without there being a factual foundation for that. So we are grateful to the many people who've done that.
And if I may, this is one way that you watching can help us. Sakeliga, we conduct these court cases, and we conduct our mission on the basis of funding from businesses like yours. But in this case, that remains relevant. But also that you can provide. You can actually help our case by providing information about what you are experiencing from a regulatory perspective. We will send a follow-up email to you. On our website, we will send you a link, should I say, to a landing page that will give you more information about what's going on, what we're talking about here today, but specifically it will give you options to fill in forms and information that really help us and really help us build the case.
Yes, and what is clear to us at this point is the PPRA is intransigent. They're not going to abandon this position, probably not. So we need to litigate. It's the only way to ensure that these requirements are not implemented the way the PPRA wants to do it. And as Piet said, to also use the same opportunity to challenge that section of the Act itself to ensure that, because you can win a smaller case on how it's being applied. But they can always come back and redesign and design a BE regime which does comply with the Act.
Yes. Okay. I want to start wrapping up, gentlemen, this section. Piet, let's talk through, and Tian as well. We've spoken about the threat. We've spoken about what we're doing. Ladies and gentlemen, this is urgent. The time to go after and end Wave 3 BEE is now. This is the right sector to be doing it in right now because of how pressing this is. I just want to let's talk briefly about what people's options are at this juncture.
Russell, they are limited. They are both limited and full of potential. Let's start with what people can do themselves. So the first is the PPRA is extending its FFC requirement regime to all 12 categories that I mentioned earlier in this webinar. If you're confronted with this requirement to have an FFC and you don't have one, strictly speaking, in the Act, you can be found acting outside the unlawfully trading because you don't have an FFC. That puts you in a difficult position. It puts you in the position where most of you have been for a while now, that you are trying to obtain an FFC. And at Sakeliga, we recommend what we call maximum achievable non-compliance. But in many cases for property practitioners today, it's not achievable not to have an FFC. So I can't speak for all categories of property practitioners here, but in many cases, in some way, you're probably going to have to try and obtain your FFC. Now, that depends on what category you're in. In some categories, it depends on your turnover, what you have to provide, whether it's an affidavit, whether it's a certificate. And all of that is really questionable because the PPRA interprets it, but it's not even clear that they interpret it in accordance with the Act. So your options is limited, and you probably have to try and obtain an FFC. Otherwise, you are liable in some way. But what is not feasible is trying to restructure your business for rules that are going to keep changing anyway. So it's actually not an option.
And that are highly contestable.
So it's actually not an option. It's an option, but it's not a good option to try and restructure your business to become level 8 or whatever BE compliant if you're an estate agent by X date later this year, because your certificate's probably not going to be in time anyway for when you need to do the application.
Yes.
And then a few months from now, there's nothing that prevents the PPRA from reinterpreting and requiring a level 7 or a level 8 or level 6. So it's the rules of the game are going to keep changing.
And we have a long history that shows us that the state has moved the goalposts on BEE over many years in various ways, shapes and forms, and we expect the same to happen here.
So depending on the industry you're in, it's probably a good idea to speak with your fellow industry participants and your industry bodies and look at your specific options depending on your industry, your turnover and so on. But it's understandable if you try and obtain an FFC. But we certainly don't advise from Sakeliga's side that you try and restructure your business and start doing business on these political terms as if they're not going to change, because that's a losing game plan. So that brings us to the option that we think has the greatest potential. And that's where we have we'd like to extend an invitation to property practitioners today to support Sakeliga with information to make this court case as strong as possible. We'll send you a link afterward if you can provide us, especially if you have been denied an FFC recently, or if you have to reapply for an FFC or apply for an FFC within the next few months and you expect to be denied because you won't be able to comply with this requirement. please let us know. We'd like to engage with you on that. We won't be able to solve your problem within the current framework, but that's why we're challenging the court case, so we can change the framework and make it possible for you to continue doing business on normal business terms. But your information will help us win that case. Secondly, we'd like your financial support because we need that to win the case. It's been wonderfully forthcoming from the industry, and we don't want to ask you to do something on that you can't afford on your income statement. But depending on your size, depending on the value you think this is going to have for the industry, please support the case financially. You can do that on our website, and that'll make us fund the case. We're a non-profit. If there's anything left, we're going to use that to win BEE cases in other areas. Because as we said earlier, Russell, BEE Wave 3 is happening in many industries.
Yeah.
And we have to find the court case that sets the best precedent for all the other industries as well.
Yeah.
So your contribution, even in this case, will actually help other cases. So that's where we think has the most potential. Now, if the property practitioners regulatory authority steps back and for some reason realizes it's going to lose the case, then that's still a win. It's just a cheaper one, and we'll use whatever you contribute to win the next case on good terms, because it's going to keep popping up unless we push back against it.
And I think that's a good time. Right before we close, I just want to. You've just mentioned that the PPRA might withdraw. We don't know, but they might start stepping back from this, sensing that this is not going to go in a good direction for them from a litigation perspective, or that the politics of the situation starts to shift slightly. And I mention this because we've just come through a national election that has delivered a shake-up, a fairly substantial political shake-up. We're talking about a multi-party government, and that has implications that are still yet to work out. We don't know where all that's going to land yet. Piet, final word from you. What does the shifting politics mean for Wave 3 BE and our opposition to it?
Russell, the shifting political situation is an opportune moment to strike. It means that the government's ability to provide coherent opposition to our efforts to reform is weak. It also means that there's a lot of discoordination there right now. And it also means that within government, potentially, there are going to be voices conflicting now on what the proper road for BEE is.
And some voices that are equally as opposed to Wave 3 as ours.
Exactly. Yeah. And so it is the time to double down right now. While there's a pause in the regulatory developments, while there is political reorganization, it's the time to strike and crush Wave 3 BEE. That's our purpose. We don't want to sit 10 years from now with a situation where we sat a few years ago, where after 10, 15 years of preferential procurement and BEE and state procurement, the whole state civil service has collapsed. So we must prevent that right now.
Okay, thank you, gentlemen. We are going to move into some question time. Thank you, ladies and gentlemen. You've been putting your questions on the Q&A section, and we're just going to try and, we'll go through some of these and read them out. I don't think we're going to be able to get to all of them. We have about 20 minutes to go, but we're going to try and do our best. And the first one is just a very practical question. It comes and it says, I'm a white female running my own real estate sole proprietorship or sole proprietor and no agents for 34 years. Do I need this new BEE qualification?
No. Fortunately, sole proprietors are exempt from having a BEE certificate.
They're exempted by the PPRA.
Yes.
But it's not clear in the Act that they're exempted.
Yeah. So there's maybe some litigation going to happen about that as well. But the PPRA's interpretation certainly is that you don't need one. And that's probably the position they're going to maintain going forward.
Yeah.
Piet, there's a question about our relationship to REBOSA and where we sit in relation to them. Perhaps you could help people understand that.
Yeah, and I'll maybe even relate it to other industry bodies. There are several bodies, like for REBOSA is in the estate agents area. Entities like the National Association of Management Agents, they do another category of property practitioners. And these entities, of course, go way back before the Act. So it's good old industry bodies. We are in a connection with several of them behind the scenes. Different entities have different approaches. Ours is we've engaged. We've concluded that the PPRA isn't going to listen and that it's appropriate to litigate. So we certainly maintain good relations with several entities, bodies, and we think that many of them do valuable work in their approach and in their lobbying work and in advising and in clarifying and interpreting what that means for their kind of property practitioner. So we've been in contact with entities like REBOSA and NAMA and others, and we think they do good work. We think Sakeliga's strength is in litigating and stopping this in its tracks, and we think that's the appropriate thing to do.
I'm just going to say there might even be some name confusion between a Leroux, a Piet Leroux and Jan Leroux from REBOSA. A wonderful surname, but no relation.
It's a wonderful surname. It's a wonderful surname. Yeah.
Okay, that's super. I'm going to read this question out, and we may or may not have an answer for it. There was a reference to attorneys' employees. If I understand Section 1 correctly, then attorneys and their staff fall under the Legal Practice Act. The effect that an attorney who is a managing agent will function under the FFC of the Legal Practice Act. Taking this into account, it seems that attorneys who are acting as managing agents do not fall under the requirements for a BEE certificate because the FFC falls under the Legal Practice Council. What is your view in this regard? There's a lot going on in that question, Tian. Do we have a succinct answer for that, or is that something technical that maybe we could reply on after this webinar?
Russell, I think there are many uncertainties with the new Act, and things are still being fleshed out and discovered as we go along. In respect of that specific question, it could be that the practitioner could be operating under an FFC in terms of the Legal Practice Act. I don't have a definite answer to that.
I could add to that. If you look at Russell at the gentleman asked the question, the PPRA's annual report of a year or two ago says that it proudly reports that it had extended this new FFC requirement to estate agents and attorney employees, so 2 of the 12 categories, and then it says within the next few years, which is where we are now, they're going to expand it to everyone. So according to the PPRA, they consider attorney employees who act as so-called property practitioners liable for their regulations. Okay.
There's bound to be some questions around thresholds and turnover thresholds and so on. Let's just recap our view on turnover thresholds. There's a 2.5 million rand turnover threshold between needing just an affidavit versus an actual certificate. Okay,
that's for estate agents.
That's for estate agents. So there's that might vary with different groups, but I think what we want to get across to people is it might be easy to comply below a certain threshold, but people need to understand that by doing so, they are playing a game. They are participating in a system. And of course, the obvious implication of that is if you grow beyond that threshold, which most businesses are desirous to do, they have ambitions to grow their business, you immediately then enter into, having played the game, you enter into a whole new and different realm. And I think for us, it's just a case of, yes, technically you can more easily comply below a certain threshold, but one's got to recognize what you are doing in that benign zone that really prohibits growth of your business and makes that growth far more trickier to handle and to manage.
Yeah, Russell, keep coming back to this term of maximum achievable non-compliance. When a requirement of government is harmful and is outside of its lawful bounds, then the ethical thing to do is to resist it. But it's not always easy to resist unethical and harmful regulations because the state is a powerful thing, and all through history, powerful entities like the state have done terrible things. The question is, in your case, what is achievable? And as things stand, it's probably to obtain an FFC is quite understandable, and some compromises are in many cases going to have to be made. But in making those compromises, we would just urge you to delay as much as you can, to make as few compromises as possible, and to realize that the compromises isn't a winning strategy. It's a time-buying strategy, because the rules of the game that you are forced to play will keep changing against you. And one of the most socially responsible things a business can do is to oppose things that harm the business environment. Because yes, it's in your own interest, but it's also for the common good. We can only have a prosperous society if we push back when the state extends beyond its proper authority.
There's a question around why can't I just restructure my business? I'm operating as a PTY, turnover over 5 million. I therefore have to comply. What's stopping me from restructuring or closing my PTY and restarting as a sole proprietor? What are our thoughts on that? Is that a legitimate course? Is that a clever way to kind of get around things in the interim? It may be, and do we perhaps think as well, though, that just represents a kind of delaying tactic until the inevitable, where regulations expand to come for sole proprietorships or what have you? What are some thoughts around that?
Yes, I think if those would be considered loopholes that would be closed, and we see this in other industries. People find ways to mitigate the effects of these regulations, these laws, restructure, and then there's a new set of laws and regulations that come in to cover those loopholes. So it could win time, as Piet said, but it's probably not a winning strategy.
Okay, but I think it's worth maybe validating some of that instinct, which is that to the extent that you can get around these harmful regulations, these harmful policies, and to the extent that restructuring represents a tolerable cost, you should avail yourselves of those types of opportunities. You should seek good corporate structuring advice. You should seek good counsel on that. But absolutely, these represent ways to delay compliance while we take this on in court, while we put a big question mark over this before a court and actually start to push back. So I think we could probably validate that instinct.
Yeah, we will not, from Sakeliga side, tell you not to make a plan. Like I said, the key here is maximum achievable non-compliance. But if you can mitigate the harmful effects through a restructuring, and it's appropriate in your situation, which you understand better than we do, and which you would be wise to avail yourself to good advice, financial and legal and otherwise, on your case, then please do so. But the winning strategy in the end is someone has to confront the state, and that's why we're there.
All right. We're just looking at some additional questions here. There's a lot of very specific regulatory questions that I think go beyond, to some extent, what we're talking about. It doesn't mean they're invalid. Peter,
could I pick that one out on the length of the court case?
Go for it. Yeah.
Maybe you, Russell, you can check some of the others and see which one we can go on. So there's a question here on court cases. They're slow. How long do we envisage this process to take? So we've had cases where we stuck to it for 5 years and we were successful. This was a major reform to the procurement situation in South Africa, and there's lots of benefits for municipalities and state entities going to derive from that. But it did take 5 years. In other cases, it can be quick. Now, how quick it happens is partly a function also of the evidence we have available, the material with which we can build the case. And that's why I come back to what Tian said earlier. If we can have, if you're willing to share with us some information on your situation, we'll review that, and we would like to bring that, in some cases, to the attention of our legal team, our advocates and our attorneys, and possibly use that to accelerate the case. This can take several forms. At the current state, we envisage a review application in which there will be quite a lengthy process, months and even years, through which we will force the PPRA to reveal some information, state their case. We will state our case, and we will try and include in that, like I said, our case has not been the final papers haven't been designed yet, but we will of course try and include in that interim measures to prohibit the PPRA from implementing some of this unlawful actions. And so it's not a quick case of when does the case begin and when does the case end, and we only have a result in the end. We can have several results in the interim that prohibit certain actions, certain implementation, and we will, once our papers are finalized within the next few weeks, based partly on some of the information you're willing to share with us after this webinar, we can give you a definitive answer on that. The case can take years. The case can be quick. It depends also on if we win, there might be an appeal from the PPRA, and that's fine. We have to just continue until we reach the Concord after that. And it can also be that the case is itself enough for the PPRA just to withdraw and say that they won't implement something. So it's a nuanced answer. We'll be clear with you on our expectations as we finalize our application.
There's an interesting related question here, Piet. I'm just going to read through this. It says, what would you suggest a property practitioner does while litigation is ongoing and the time for new FFCs are upon us? This is a very relevant question. By implication, one would either go through the points gathering exercise, maybe restructure your business so that 51% shareholding is sold or given away or what have you. And then it says, if litigation is successful, one had either wasted one's time or given away shareholding or sold shareholding against one's will for your livelihood with no way of getting it back for the same value as you had given it away. And I think that's a very relevant question because it comes back to what we're saying. Don't over-comply and rush to be restructuring your business. This is time to stand against this. We are standing against it. Now, we know that there are practical issues around this. And by the way, when we talk about restructuring, we're talking about restructuring in that particular way. There was a previous question around sort of technical restructuring around PDYs and sole proprietorships that represent the kind of loophole usage that maybe we would validate that could be valuable. So it's relevant, isn't it? And I think part of your previous answer, is that during the process we would endeavour as much as possible and must endeavour as much as possible to get the kind of relief from the court that would put this thing on hold, put it on pause, and say, right, there's a big question mark over this thing. This is before a court now, and so basically, let's pause this thing. Some kind of more urgent relief, as it were. That's a technical legal term, but just more urgent relief from the courts. So I think that's kind of our thinking on this. There's a question about how agencies can help build this case. We've already touched on that. You can give us information. And funding is very valuable to us. Depending on the size of your business, we greatly value 500 Rand, 1,000 Rand a month, 2,500 Rand, 5,000, 10,000 Rand a month support for these efforts, depending on the size of your business. It should be something that doesn't bother you on your income statement too much, but that you believe that you can be making a considerable impact to what we do. We really appreciate that support. It makes a huge difference.
Russell, while you're looking at questions, can I make another remark?
Yes, indeed.
Look, Sakeliga has litigated many times, and we've been successful almost always. But litigation remains a tricky business. And we're not sitting here today giving you a guarantee that this case will be won on the terms that we hope it will be won. We are very positive about our prospects based on the advice we have, also based on how things are changing in the country. BE is questioned by virtually everyone today. I just recently watched a very nice clip by Lamberti and Piet where he just destroyed BE as a very, very harmful policy. So BE is delegitimized in the eyes of virtually everyone in this country, and also we frequently interact with foreign businesses and foreign trade representatives in South Africa. They certainly don't see this. BEE is considered an illegitimate policy. Now, as BEE loses its authority more and more, litigation also becomes more and more pertinent, but as well with greater prospect for success. But let me we believe it's a great court case, and we're committed to it. But there remains uncertainty in court cases. And so that's why we must also continue our public presence against BEE, because in the end BEE will be stopped through the courts, but also because people in this country no longer tolerates this kind of political intervention.
Can I also just say this? If one of the participants have an FFC denied in the coming months, we would like to know about that. Even after our court case has started, we'd like to stay ahead of things, and it would really help our case to know.
I'm going to field a final question with a quick answer, Piet. There's a question about the fact that the Competition Commission is getting in the way of deals, and of course this will affect people in the property sector because there are property transactions. Yeah. There's large transactions that go through between property businesses. Is this something that Sakeliga will also be challenging in time? Maybe just briefly sketch how we are thinking about the Competition Commission.
We think the Competition Commission is completely out of line with its harmful BEE requirements. There's a problem there that needs to be solved, but it's a complex problem. The Act itself has problems, as well as the regulations, the written ones and the unwritten ones in that Department of Trade and Industry. We are investigating the department. We have several PIO requests, which are information requests. We'll use these information requests to understand the situation. If you think that, if you're aware of a case, an application, a denial of a merger on acquisition that you'd like to share with us, please do so. We can't advise you on how to make the deal work, although we advise a firm posture, and we've actually come across several businesses who've just said, keep saying no, and in the end the Competition Commission just accepted the deal. So it's also a question of whether you can stay, you can firm up enough, and if you have enough time to buy. But please let us know. The Competition Commission needs to be addressed, and we're trying to figure out how.
Tian, Piet, thank you, gentlemen. Thank you for your time. Ladies and gentlemen, thank you so much for dialing into this webinar. We greatly appreciate your attention on this very, very important matter. Thank you for joining us today. Thank you for the support that we've gotten from the industry. It's been very heartening and very encouraging to Sakeliga. So thank you so much for that. There are a lot of questions that we haven't been able to get to today, and I'm going to maybe give some work to my colleagues, but we might consider just putting some of those anonymously into an email and just providing a couple of short answers to some of them where we think they are relevant, and that might be able to go out in a broad communique to all of you. So some of your questions we'll try and get to, and we'll try and not give you individual answers, but perhaps send those answers through to the group. So thank you so much for those questions. Thank you for your participation. All the best until next time. Take care.